Welcome, and thanks for joining us at the Grown-Ups Table. I'm Dave Patterson.
And I'm Dylan DeQuano. This is the podcast where we talk to you about the shit that you never learned, but you probably should have. What's going on, Dave?
Cannot complain. Beautiful day. Finally some mild weather. I mean, it rained a lot, but at least it was mild, so I'll take it.
Not nice for me. I was driving in rain.
Remember like a week and a half ago when we had snow?
Yeah, that's better. It's better than that. For sure.
A lot better than that. What's going on with you?
Yeah, I don't know. Just I took a day off work today because sometimes it's good to take a personal day and just get some things you need done in your life that, I mean, I have the luxury of doing that. Luckily enough, I know not everyone can just take a day off here and there, but I did today because I wanted and needed to. So, yeah, taking care of some stuff. I know that we always ask the what you've been doing question, so I have an answer to that if you want to ask me.
Well, I mean, if you're going to lead me on like that. So what you been working on, Dylan?
Yeah, there we go. Thanks. So I had a fence guy come today and give me a quote on a fence for my backyard because I really need to get that done because we have a dog.
Nice.
As you know, little Louie, he's a Chihuahua. He's a rat. And if we let him outside, he will just run into the street like he just did, actually. I let him outside to go pee, and I said, okay, let's go. And then he saw another two small dogs across the road, and he just ran after them, and I was calling him, and he wouldn't stop. He just fixates on other dogs. So, yeah, I don't want to have that happen anymore. So we're going to...
Time for a fence.
Yeah.
Yeah.
It's hard to get a fence, though. Like... Right now, like, it's just so backed up. And
are you looking at wood?
Yeah, we're doing wood.
Right, so that's going to cost you right now.
Yeah, we got a quote. It's actually less expensive than we were expecting based on another quote that we got. So we're just going to go ahead with it. But yeah, should be 6 weeks out on that. So
it's not too bad, really, for jobs like that.
Yeah, at least it'll be done. Like, and have most of the
especially
summer.
Like in springtime to hire someone for that.
Yeah.
They get booked up quick this time of year.
Yeah.
Yeah.
So that's what's going on with me. What have you been working on?
Well, I had a little rodent problem in my backyard back in December.
I remember you mentioned that once to me.
Yeah. So I had an exterminator. He set up these bait boxes. Seemed to be taking care of it. Hadn't seen any activity, but I'd seen some crawling in my shed. So I boarded up the shed. We left some bait in there. The bait wasn't taken, or at least I didn't think it was taken. So we figured, okay, shed's free of rats. So it was sealed up. Was moving some stuff around on the weekend and thought, oh my God, what is that smell? And I found some rats that I think had been in. It was at least, it's hard to say, man. Kind of like morphed shape.
Oh, yum.
It was either a big fucker or two died while like spooning.
So you didn't keep him out, you kept him in.
Yeah. I killed him. Got that part done.
Wrong way.
Yeah. Just wanted to do that outside of the shed. So yeah, pretty sure they shit themselves to death. A bit of a mess.
Gross.
So I dealt with the worst of it, and then this week, once the weather improves, going to have to sanitize the whole shed.
Good stuff. And you put them on a stake and threw them over a fire and made sure they...
Oh, yeah. Little redneck supper.
Yeah.
No, they went... I had the mask on, the gloves on, biggest shovel I had, right into the garbage bag.
There you go. I would just knock down the shed if I were you. Just like, I'm done. No. New shed. This is gross. No, that sucks. But at least you know that it's taken care of. They couldn't get out, so that means more can't get in, hopefully.
That's the hope. I mean, I don't want to bet on it. But yeah, that was a part of a much bigger project of decluttering. Filled up my whole vehicle with crap to take to Goodwill.
Nice.
So nice to get some stuff out of the house as well.
Yeah. Fun times. Well, what are we talking about today?
Today, we are talking about small claims court.
Ooh. I knew that already, but our listeners didn't. So I
wasn't sure if you forgot. You actually sold the reaction, though.
Good. Yeah. I was just reacting like I am hoping are reacting when they hear the word small claim. That's how everyone I know reacts when they hear small claims court. Ooh.
So I take it you haven't talked to anyone about small claims court. You've just listened to the studio audience of Judge Judy.
Pretty much, yeah.
Okay, yeah.
Yeah, that's how they usually react when something juicy happens. That's what I imagine.
Something juicy. I feel like if you're waiting for the juicy details, it might be a disappointment.
Yeah.
In the real world.
Well, we'll find out. Have you ever been to court?
No comment.
Okay. Have you ever?
I've been to small claims court.
You've been to small claims court?
No, I have not.
Oh, you've only been to big claims court.
Well, I'm not sure you know how courts work.
But that's why we have Reilly coming on today.
Yeah. Reilly's the expert. She'll know a lot more than either of us.
Yeah.
And we're able to break things down. Because the more I try and understand the legal system, the more it ends up being so broken down. It's kind of like medicine or something where you see a different doctor for your eyes than your ears. Like everything's very specialized.
Yeah.
And it's not just the same way with lawyers. Like there's so many different types of courts you could go to and things like that. So it'll be good to talk to Reilly about small claims court, which is one that a lot of people end up actually having some experience with. I know I almost did 2 years ago over a sold car dispute or used car dispute.
Okay.
But they realized that I'd have wiped the floor with their asses and smartened up.
There you go. Well,
yeah, no, I don't know. I got lucky. They fucked off, whatever.
You scared them. People don't like probably hearing the word small claims court. They don't usually react with, ooh. They usually probably react with, no, I don't want to do that. Let's just figure this out, man.
Yeah.
So, but I mean, sometimes it doesn't end up like that. And
sometimes you got to do what you got to do.
Get someone else to mediate for you and figure out who's in the wrong and who is owed some sort of compensation for the wrongdoing or how to make it right. So,
absolutely.
I've never been to small claims court. I only had to go to court once before representing my company. I work in insurance. I work for an insurance company. I basically had to go and be there in case the person who was driving without insurance tried to tell the judge that they had insurance. Then they could call upon me to go up and say, I can verify that they did not have insurance. And that would all be that I do. But I've never been sued. I've never sued anyone.
Were you nervous? Were you nervous they'd call on you?
A little bit. It was
I
kind of liked it. I think I actually had to do that twice. And I liked it, to be honest, because from what I had heard, most people don't get called in those scenarios because the person knows.
Right.
But I got to dress up and wear a suit. And I got to go downtown Toronto for the day and go to the courthouse where I'd never been before and take like a half day off work, but got paid for it. So it was sick. Like I liked it, but I didn't have to do anything. I was a little nervous though, because what happens if you go up and then you say something and then I'm like, oh, I said they didn't have it at the time, but they did have it before. And that's what they showed. I'm going to jail now, aren't I? That's my worry about court. I've seen way too many or not enough court dramas to really know how this works.
Or not good enough ones.
Yeah.
Well, I actually think Reilly's in the green room ready to join us now.
Yeah,
so
sounds good.
Head on over.
All right, let's do that. All righty, we've got Reilly Cservenyi here with us. Did I do that okay?
That was very good.
Perfect. That's what I was hoping for. How you doing, Reilly?
I'm doing well, thank you.
Good.
Do you want to give us a little bit of background about yourself and what you do and why you're here to talk to us about small claims court today?
Yeah, absolutely. So a couple years ago, I kind of joined forces with another paralegal in Cambridge. That's where our office is. and we created a partnership. So the official name is Reilly Cservenyi LLP, but for obvious reasons, we go by DC Paralegals. And then we just got increasingly busy. So we've actually added 2 more paralegals to our firm that started with us in October of last year. The pandemic's hurt a little bit, but we're still getting busy. People still need legal help. And so we're here to do that for anyone who needs it.
Amazing.
That's fantastic.
Yeah.
So how long have you been like practicing as a paralegal?
It would be about 4 or 5 years now. So I started at a larger law firm in Guelph, and then I actually worked for a collection agency doing all their litigation for about a year. And then I met Jane Dean, who's my business partner, through actually suing one of her clients. And then after we resolved that, we went out for coffee and decided to become business partners.
Does that happen often? That sounds like it would be a pretty rare way to meet a future business partner.
Actually, I mean, the movies like to make it seem like people like opposing counsel on files are like this very adversarial process. It's really not like that. It's most of the time 2 people trying to get the best resolution for their clients. And it's usually a very cooperative process, not us fighting all the time. So I actually have a lot of friends that I've met in the profession through, being on opposite sides of a file.
And that kind of makes sense too. I'm sure it's a pretty small world, and you get to see a lot of the similar people if you're in a certain type of like law, and what kind of people are suing the same kind of people, are looking for the same kind of lawyers or paralegals to assist them in like what they're doing. But I have a question right off the bat. I feel like a lot of people, like myself included, hear about lawyers a lot, but don't really know exactly what a paralegal is. So can you kind of explain the difference between a lawyer and a paralegal to listeners?
Yeah, absolutely. And that's something we get a lot. A lot of people think that paralegals are kind of in the same capacity as a law clerk because that's what you see in the TV shows, because that's what it's like in the States. In Ontario, paralegals are licensed to practice law. That only happened in 2007. And basically, you can think of it kind of like a registered nurse to a doctor. So we can do a lot of the same things, but a lot of them we just have a cap for. So small claims court goes up to $35,000. And then we can practice in a lot of the boards and tribunals. So you're going to see the Landlord Tenant Board, WSIB, Human Rights Board. So there's actually over 500 tribunals in Ontario, and we can practice in all of them. But basically, we can represent clients, and it's just up to a certain amount.
Gotcha.
Wow.
Yeah.
So often, like a small claims court, from my understanding, is anything under $35,000. So if anyone is trying to sue someone for an amount of that or less, they would be going to see a paralegal in Ontario rather than a lawyer for the most part.
Well, I think that's a lot of the trouble with our profession is we're still getting that out there and getting people to be aware of paralegals, because a lot of the times people will still go to lawyers and then you're paying more, but it's also like, this is what we do, right? Like we do small claims court. This is what we're trained in. This is what we do every day. Where a lawyer typically does superior court or different areas of law. And there are lots of different nuances in small claims court. The rules are different, practice and procedure is different. So I would argue that if you get a good paralegal, you'd actually be getting better representation in small claims court from a paralegal than from a lawyer, because it's like our bread and butter, right?
That makes perfect sense. And that's really good to know, because I am, I guess, one of those people who wasn't on the up and up about all the the like stuff that a paralegal can do in terms of law. But before we get into the conversation too much, we always ask
a couple of housekeeping things to discuss here.
Exactly. What are we drinking tonight?
Well, I've got my Wellington SPA. I even have the Wellington glass.
Oh, nice. Oh.
Yeah, I'm from Guelph, so I got to be true to my roots, and I got to drink my Guelph beer. So that's what I got.
That's great.
Perfect.
I just opened mine too. It's actually really good. I haven't had one of these before. I've had Wellington beers before, but not this one.
I have had the Wellington SPA before, and I really enjoy it, but it was not available at the LCBO near me when I went to go pick them up. So I picked up the Wellington Imperial Russian Stout, which I've never tried. Ooh, it's 8%. So I might be silly by the end of this episode.
Yeah, we better get Dylan's questions in early here.
Cheers.
Cheers, guys.
Ooh, that is delicious.
We talked a little bit about what a paralegal is and what a paralegal does, but what exactly is small claims court? Because most of us, we hear about it once in a while, but we've never actually experienced it. So what is it?
So, I mean, it's obviously a legal venue. So we talked about the cap earlier is $35,000. So that was recently raised. Before it was $25,000. They've been talking about making it $50,000 forever, but we'll see how long that takes. But basically it's to litigate any dispute. Usually it comes from a contract. So if you've contracted into something, whether it's a renovation with someone or a commercial lease or something like that, and then there's some type of dispute. So it can come from either side. It can either be, if we're talking about a contracting situation, which is what I do a lot of, if you're a homeowner and you have someone come in to renovate your kitchen and they botch the job, you might want to sue them for the money that you paid them or the money it takes to repair that or something like that. On the flip side, then you've got the business where perhaps they did, again, a kitchen renovation and then they never got paid for the job. So there's a lot of unpaid invoices. We have a lot of small to large companies that are just trying to collect, but it is a lot of contractors and services like that.
In terms of if it's someone like you get work done and you haven't paid them, is there a time limit to when they are allowed to bring you? Or is it just like you didn't pay within this first agreed 30 days, so now we're suing you right off the bat?
So, I mean, usually people do try and work it out beforehand. If you have some type of accounts receivable department within your company, or a lot of people will go to a collection agency first, but there isn't necessarily a minimum time. You don't see a lot of people if your invoice is due January 1st, going to sue someone on January 2nd, because it doesn't make financial sense to kind of go that way without trying the easier route first, because you're going to be spending money to get that back. But there is a limitation period when it comes to how long you can wait before you can no longer sue them. So that's 2 years. So if you have an invoice, again, that was due on January 1st of 2020, you would have until January 1st of 2022 to commence that action. If you wait too long, then you can't go through court to get that anymore.
And that would just be, you can't go through small claims court, or you can't go through any form of court, like if it's under a certain amount of money?
You wouldn't be able to basically litigate it in any way. There is kind of caveats to that. So if someone admits that they owe it, whether they make a smaller payment or they write you in an email, I know I owe you this, just give me a couple more days or something like that. That can be an argument to extend that limitation period, and it would start from the date that they admitted it or the date that they made a payment. That can always be an argument, but you shouldn't wait 2 years to recover your money anyway.
I was going to say, that's on you after a certain point.
Exactly, yeah.
Sounds like the courts agree with that statement.
Yeah. So we talked about the cap for the upper end of what can be done in small claims court, but is there like a baseline for how do you know if you even qualify for small claims court? Because presumably at some point people would just waste the court system's time with all kinds of nonsense.
Yeah, there isn't a technicality that says you can't sue under a certain amount. That being said, if we have a client come to us and they have something that's under $5,000, we typically advise against it, especially if they haven't tried other methods like a collection agency. That being said, if it's a simple unpaid invoice, sometimes we can charge a little bit less for that because it's not as involved of a claim. And then sometimes people just do it based on principle. There are those people who are like, this person owes me the money. I don't care how much money I spend to collect it. I want to sue them. And we're happy to do that. We just let them know they might spend more hiring us than they will end up recovering in the end.
We talked a bit about some of the different ways you could end up and how contract situations often tend to be the bulk of it. And we've talked about if you're owed money and outstanding invoices, all of that. But what about something on the other end? If you're the customer, what kind of reasons, like we talked, again, contractors and work jobs like that, I know are very common, but what are some other reasons that somebody who's a consumer, so to speak, would end up in small claims court or wanting to go to small claims court?
Yeah, I mean, it could also be in the context of if you bought something from someone and it didn't kind of serve its intended purpose. So as a consumer, if you were to buy, I don't know, like a lawnmower, and then it was, I mean, obviously if it's used, it's a different situation. But then if it broke down or something like that, then you might sue for the damages there. It's all, right. I mean, it's gray area all over the place in law. But yeah, it's basically any time that someone has caused you what we call damages, which is just financial loss. And we could litigate that. It just kind of depends on what we get. A lot of people who don't have the documentation or the evidence to back it up, which can be a little bit hard. But we can really kind of pursue anything if you want to.
Fair enough. Well, with that, let's say you do get sued. I'm going to assume most of the time you can probably anticipate it. Like you're not just going to randomly get something saying that you're like that a lawsuit is being presented against you. But what does it look like when a lawsuit is being presented against you? You just get something in the mail being like, you got to show up to court this day and that's it? Or how does it work?
So it's a little bit of a process. So basically the initiating document through court is called a plaintiff's claim. So it's obviously the plaintiff and the defendant. And so the plaintiff makes a claim against a defendant or several defendants. They would have that document issued with the court first, and then it has to be served upon all of the defendants. And so it's not just in the mail. It would have to be either personal service, which is, someone handing it to you. And you always see it in the movies, like, you've been served. Yeah. Or you can get it over courier. There's different ways of service. But that's the first step. And then if you are presented with a plaintiff's claim, the next step is you have 20 days to defend it, which again is another court document that you would fill out and explain why you don't owe this money. And you have to do that within the 20-day period. And then you again serve that on the other side, and then you would file that with the court. Once that has been done, then the court date is set, which it's a mandatory settlement conference, and that's in all small claims court files. And you'll be in front of a judge, and you can kind of discuss your case and see if you guys can come to a settlement. If it doesn't come to a settlement, and then the next step would be trial. But it's also, and this is kind of the thing that is I think the most important thing is that we've seen a lot of people have this kind of avoidance culture. And we saw this a lot when I was in the collection agency, is people are great at avoiding collection calls. And then they get this document in the mail and they decide, I'm also going to push that aside and not deal with it. And if you do that, then your 20 days passes, you can get a judgment against you without ever seeing a courtroom. So if you get this plaintiff's claim and you decide I'm going to ignore it, you'll have a judgment against you. Not only is that terrible because it goes on your credit, and it is terrible on your credit report, but also then we can start to do crazy things like garnish your wages, garnish your bank accounts. We can put liens on property that you own, all of that. So it's very important that if you're served with a court document, that you follow up with it and do those next steps.
Gotcha. So
yeah, you don't want to end up down that road.
It's terrible.
And like it always shows in the movies and stuff, when you're getting served, it usually seems to be a person hand delivering it. Is there any part of that it must be like actually verified that it was given to you? Like if it's just sent in the mail, is there any confirmation that you ever received it?
So that's why you can't do regular mail for an initiating proceeding like a plaintiff's claim. But you could do courier as long as you get that signature confirmation. So if you have it signed by the person, then that's considered effective service. But right now, again, with COVID, they're not doing the signatures. So we've had to do personal service, which is like a person handing the person the document.
It seems backwards that that's the solution during COVID, but anyways.
Yeah.
But before we move on, and we're on this topic, does anyone here have a favorite movie where that happens, or TV show example? I'm going to go off the top here. Pineapple Express, Seth Rogen. Oh, I stole it. Sorry. But it's so good. You, sir, have just been served. Oh, fuck you, man. Like,
it's not quite that exciting.
No.
But yeah.
That's what I like to imagine all of them are like, but I'm sure that's not the case.
It's what I picture. I don't do service. We do have a couple of the paralegals in our firm that they'll serve documents, but I don't do it.
Do you hire out just service people? Can anyone do it, or do you need to have some sort of specialized training?
Yeah.
Like,
I mean, anyone can do it, but there are lots of places that you can hire, but I like to just, if I have a claim, I just have one of the paralegals in my firm serve it so that the money kind of stays in the firm, and why not?
Mm-hmm. Yeah.
There are lots all over the place that you can get service.
Dylan just wants a job where he just tells people they've been served, I think is where that was headed.
It looked pretty fun. He just kind of chilled in his car all day, showed up, delivered a letter, smoked a lot of weed.
Yeah, and he had all the different like costumes on and stuff. Yeah, no, that's amazing.
We talked a bit about what to expect when you've been served. But either way, whether you think you have a claim you want to take to court or you have been served, how do you know when this is something you're probably going to need some professional help on? Because I'm sure there's a lot of people, especially on smaller things, think, oh, I can argue my way through this. And maybe some can, depending the issue and how clear cut it is. But how do you know when it's time to find a paralegal?
Yeah, I mean, obviously, as someone who is a paralegal, I'm going to say just talk to a paralegal first, at least. But I mean, the small claims court was supposed to be designed to be tailored to the self-represented person. Unfortunately, there's so many little details that if you're not really going to take the time to go through the website, maybe call the court clerks to understand the process, you might get tripped up on a lot of little nuances that are then going to set you back. And end up costing you more money. I have lots of people who come to me at a certain point and they say, the court just won't accept this document anymore. I don't know what to do. I go through all their documents and they made a tiny mistake at the beginning. That's now cost them a whole lot of time, and we have to go back to the beginning and start again. But we do offer a service where if you are interested in representing yourself, you can still come in and have a consultation with us for an hour and a half, or as long as you need. And we just charge you hourly for that. And then you can get a better idea. You can ask your questions, and that way you might be on a better trajectory. Because it's a lot more than just arguing in front of a judge. And it's actually just a lot more than just being right. You know, there's so many different things where you can have what you'd consider a slam dunk case, and it can go sideways really easily. So.
Right. And when you're like in this situation, obviously you don't know what kind of evidence maybe the other side has against you. So I guess like as a paralegal, like you don't really show your cards until you're in the courtroom. Do you have any, or I don't know, you look, your reaction says
well,
something.
I guess if you're trying to reach a settlement, maybe.
It's actually not the case. So when you are drafting a claim, especially in small claims court, you are supposed to be attaching all of your evidence that you would use if you go to trial. And likewise, in a defense, you should also be attaching all of the documents that you would use. And then It's intended that before the settlement conference, you again disclose all evidence that would be used at trial. Now, of course, things come up beforehand, but you need to disclose everything you would use at trial at least 30 days prior to the trial date, unless you get the consent of the other side to do it in less than that amount of time if something comes up. So it's not, again, like in the movies where people
I was going to say
evidence, and no, it just doesn't work like that. You know, and like you said, it facilitates settlement, right? And everyone wants to settle their case. No one wants to go to trial because it's just expensive and it's stressful. And so by disclosing everything that you have, the other side can fully assess, okay, I need to settle, or no, I'm not going to settle, right? So when you brought up settlement, that's exactly why they do this.
Right.
That makes sense. Yeah, there's so many movies where they're scrambling like just before the case is over.
Yeah.
What are the consequences if, like, I win a case and the defendant can't afford like what they owe me?
Yeah.
Or they don't have any assets to their name. You just don't get anything?
So, I mean, what we do, so judgments in Ontario, they don't ever expire. They used to expire after 20 years, I think, but now they never expire. So again, say I have a judgment against Dave, and right now you don't have a job, you don't own a house, and I don't, because if I know your banking information, I can take the money from your bank account if I just know the branch that you bank at. And so what I would do in that situation is in a couple years or less, depending on if I know anything about the defendant, I might pull a credit report to see, oh, look, he's employed here, or he might have bought a house here, or there's different ways of finding that out. So it would be a matter of either the plaintiff who has the judgment or their representative to continue to follow up to see, do they have any assets now? Do they have a job now that I could kind of go after? And the other factor is what I had mentioned before, that's going to be on your credit report. So when you do go to buy a house, you're going to have a really hard time doing that.
So you end up being kind of a private eye as well, eh?
A little bit, yeah.
Yeah.
If you need to be.
Yeah. Well, and like you just said, like this is something that impacts your credit score if you lose a case. Yeah. But when you're filling out your job application or whatever, and it says, have you ever been convicted of anything in Canada? You have not been convicted of anything. No. You didn't commit a crime, but you lost a, what do you call it? Like just a small claims case?
Yeah. 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 No, it's not a conviction. A conviction would be more like criminal activity.
Right.
Yeah.
And then on that front, you said that you'd be maybe like at the Kitchener-Waterloo courthouse or the Brampton courthouse. Are they the same judges that preside over small claims court cases and regular is what I'll call them, but maybe what were the real terms? Superior court or
in Superior Court?
Well,
Superior.
So many different levels of judges.
Yeah. What are they? Because I don't really know. I'm not involved in the court system. I don't remember.
Yeah. So they're called deputy judges, and usually they're part-time. I think there are some that are full-time, but most of them are still running their own practice as lawyers. And then they're also deputy judges that sit on certain days. And then there would be obviously different ones based on the courthouses. So there's a few at KW and a few at Brampton and all over. So right now we're getting a good kind of spattering of everyone because it's virtual. So it doesn't matter what jurisdiction they're in. So you kind of get used to the judges in your own courthouse. And now all of a sudden we've got ones from St. Catharines or like all over the place because they're all virtual hearings right now.
Right. I was going to ask about that. If there was any in-person cases going on in the court system, or if everything right now is virtual just because of the way things are.
So, I mean, everything for me, I do mostly obviously small claims and then landlord tenant, and it has been online. I do know some criminal cases are going forward in person if they're like bail hearings and stuff like that. I don't want to speak too much about that because that's not my practice area. And so I don't know for sure, but I do know some criminal things are going forward in person, but basically everything's online. But unfortunately, They only really have the capacity to do certain things. So I had talked about settlement conferences. Those are going ahead virtually. However, I haven't yet had a trial virtually yet. But I do know that they're working towards that. So I have a trial that was scheduled for March 17th of 2020, and everything shut down, I think, on the 14th. So that one still hasn't gone forward, still hasn't been rescheduled. I don't know when it will be.
Well, what if it gets past the 2 years?
So that's just for doing that first document. So as soon as you issue the plaintiff's claim, you're done with the limitation period.
Right. Okay.
Yeah, that makes sense.
Gotcha.
So we've talked a lot about contracts and having things signed, saying who owes who what and why. But what about a situation where maybe you hire somebody to do a job and you never put pen to paper? Whether you just kind of gentleman's agreement, so to speak, to build a garage for somebody. I'm sure it happens all the time. Can you still go to small claims court with that? Yes, you can. It's obviously going to be a little bit trickier, but I have had cases decided based on text messages before. So I had one where it was, again, a contracting issue, and the contractor had texted the client and said, I'll do your floors for $10,000, your cabinets for $9,000, like just a list on a text message. And the judge considered that a contract because it was confirmed, and then it was obviously carried out. So there was no written contract, but text messages and emails will get you a long way. But in the absence of all of that, you can still, a verbal contract, we always say, is as valuable as the paper it's written on, but it's technically a contract. It's just, you're going to have a lot of he said, she said kind of issues. Yeah, that makes sense. Yeah.
Right. I had a thought about that. I can't remember it now. This Imperial Russian Stout is going through me.
Well, I've got another one then if you need a minute to regroup there, Dylan.
Go for it.
So let's say somebody decides to go in, whether it's for representation from a paralegal or for a consultation, like you said you'd recommend, which makes a lot of sense, especially if you've never been through this process before. What kind of stuff do you need to get together to prepare for that? Obviously, any contracts, but like if somebody walks into your office for a consultation, what could they have done ahead of time that makes their time with you more valuable?
Yeah, basically it does come down to having any type of contract and then kind of like a timeline. Because a lot of the times that's very important, especially if it comes to limitation periods. I mean, we said no one should be waiting 2 years, but you have no idea how many people come to us and there's a couple weeks before the limitation period would expire. So knowing that information, but we do typically do a short intake on the phone before they would come into the office. And in that time, we would kind of discuss with them what they should be bringing in with them. But it is mainly, if they have any type of contract, if it does come to a contract or things, there's usually quotes, any kind of correspondence. We don't necessarily go through it all at that time, but I always say, bring me everything that you have that's relevant to this, and I'll decide what is relevant and what's not relevant for the court case. And then, if they're going to go forward with it themselves, we could obviously go through it quickly with them and kind of coach them through what would be relevant and what wouldn't.
I did remember my question that I had, and I don't even really know if it makes total sense just because I'm not sure about all the like ins and outs of things. But if something like if a piece of information comes to light about someone who is a defendant in a case where they are practicing something incorrectly with this client, and it comes to light that they are doing this with all of their clients, can it ever get extended to another level where this client would be like liable for a bunch of different things in the past that they've done? Or is it just like what happens in this case stays in this case?
So that's an interesting question. I mean, so once court cases are in the system, they're technically accessible to anyone in the public. So they're all public record. You'd have to go into the courts and look it up. But it isn't private and there's no confidentiality except for if it was privileged information. So that, like a settlement conference would be privileged. You can't really talk about what happens in there because it's supposed to be open and honest discussions between the two parties. But it is technically public record. So, I mean, it seems like you're kind of maybe talking about a class action. Like maybe
where I'm going is like, let's say you have someone who redoes your kitchen, and then you're bringing them to small claims court because they didn't really follow through with what they said they were going to do, but they were recommended to you by someone else. And then when you tell someone else, yeah, I'm suing them because like they didn't do it. And then they're like, hey, that happened to me too. Yeah. And then the person who recommended them to them also has had the same experience. Now you're like opening a big can of worms.
First of all, your friends suck at recommendation.
Yes. So I have actually had something very similar to what you're talking about. So it was a company who provided services. I won't go into detail with that, but I had one file, and then I happened to have another person call me 2 or 3 weeks later, and their experience just sounded so similar, and it ended up being the same company that they were suing. And I ended up having 4 files from different people against this same company. And then I actually found another paralegal who had a handful of cases against this company as well. So they're clearly not very good at their job. But that was how it was happening, was people were posting on forums or the Better Business Bureau or just, on Facebook ranting about their terrible experience. And through that, someone contacted them saying, this same thing happened to me. And then they said, you need to talk to me. And they called me. And so we had several cases against the same company. So I don't know if that's what you're talking about, but
pretty much. Exactly.
There are certain people who you're going to find are in court quite a lot because of improper practice. But I don't know how that's a sustainable business plan, to be honest.
I was going to say, that's going to catch up with you eventually.
But that doesn't like bring it to the next level of no longer being small claims and this is now a class action. Like, I don't know where you draw the line and what becomes a class action versus just like 10 people are suing this guy for the same thing.
So, I mean, I believe I've never done one, but a class action would be more where a bunch of people go together and sue them, and that's usually in the hundreds of thousands, if not millions of dollars. And I feel like that happens against like pharmaceutical companies and things like that.
Right.
Now having a bunch of individual plaintiffs suing the same person, they're all separate cases that would be dealt with individually. It was just kind of that it kind of opened that can of worms in the way that you were talking about, but they didn't litigate it together. It was all separate actions.
Okay.
Makes sense.
Yeah. And I did remember another question I wanted to ask earlier. You had mentioned you get used to working with a lot of the same judges by being in the same courthouses and things like that. Like, after a while, do you get to kind of know, like, this judge always kind of leans this way, and like you kind of tell your client, like, the judge is going to lean this way because I know them and that's the way they are. So this isn't worth doing. Is that something that ever comes into play? Or if they want to do it, they just like, they've got to do it. But
yeah, I mean, you'd hope that it was never in a way that would completely bias a judge in making a decision against what the law says. But there are definitely judges who have biases. Sometimes it's against women. Sometimes it's against paralegals, because oftentimes paralegals are seen as that like second-rate legal representative, right? So we deal with that sometimes, but more times than not, it's simply me saying to my client, oh, this judge really likes to hear his own voice. And so we're going to be in there listening to this judge rattle off all his experiences, and it's not going to get us anywhere. It's more often those kinds of things. And a lot of the time you don't know who the judge is until you're at the courthouse that day. So it's not as though you could tell your client a couple weeks before, look, this is the kind of judge you're getting. So watch out for this or that. It's usually the day of that you would figure that out.
Cool. That makes sense. I know we talked a lot about how movies and TV kind of make courtrooms seem a lot more glamorous than they are. But one of the ways they do that is with people just dressed to the nines every time they go to court. And I remember seeing a hilarious video of the opposite of that a few years back, of some dude in Miami and like some low level court where, you know, they're calling people up for traffic violations, and they call him up and they read the charge, and he's charged with stealing one Miami Dolphins jersey. And then the camera pans out and the dude's standing there wearing the Miami Dolphins jersey. So that's a great example of what not to wear for your court case. But what should people wear if they're going to small claims court? Is this a formal thing? Do you want to like represent yourself well, or is it just kind of wear whatever?
Yeah, it's kind of all over the board. So when it comes to a representative, you will get reamed out if you are wearing something that's inappropriate or too casual, and that's obvious. We're being paid to be there. We should, you know, be presentable. Yeah. When it comes to my clients, I usually tell them, at least, because it's a lot of contractors, to be clean, you know, wear maybe a polo shirt. Like you definitely don't have to wear a suit. I've had clients come in jeans before. It's not ideal, but it's not really a huge deal. Again, this will come down to what kind of judge you get. Right. I've had other representatives tell me that they were in a suit, but they didn't wear a tie, and they were sent home to put on a tie before they came back.
Really?
And that is not common in small claims, but you will get the odd judge like that. But usually, I mean, if they're for a company, I have a lot of people who wear like their company polos with their logo on it or something like that. But as long as you're clean and, I don't know. Yeah, it's pretty relaxed, but
that's kind of funny though, that like the judge can just kick you out because of what you're wearing. Like, is there anything written in law that gives them, like, is the judge just the all powerful mighty being that what they say goes? Like, I guess they are, but like,
that's where appeals come into play. So if they do something completely unreasonable that then prejudices your client, you would go for an appeal on something like that. Again, you have to decide if the cost is worth that for the amount that you would be appealing. But you won't find a lot of judges do those things. But yeah, they do have the right to do that, which kind of sucks. But
yeah, I mean, like everyone has a different interpretation or maybe different access to and means Absolutely. Of acquiring. Like, what if someone just like legit doesn't have a dress shirt? They only wear t-shirts and jeans, and they just simply don't have a suit. Now they have to go spend a couple $100 to go buy some nice clothes because they got a judge who doesn't like them not wearing a tie in court. Like, that seems like not really the point of the case. Is not about what you're wearing.
Yeah. And I will say, when it comes to someone who's self-represented, or when it comes to the witnesses, or even just the parties in general, the judges are a lot more relaxed with that in general. I've never had someone thrown out of the courtroom for what they were wearing. I've just heard stories. So,
yeah. So it's not a common issue you need to be that afraid of.
I hope not. And now with Zoom, it's like, as long as your top half is good, you're golden, right?
Yeah. Have you had anyone have the kitten filter on in one of your...
I wish.
I can't turn this off. I'm not a cat.
That was my favorite part, that he clarified he is not actually turned into a cat.
It's so good. There was one time where I was on a hearing, and the judge had one of the backgrounds on, and it made it look like she was sitting on the bench. So with the seal behind her. Huh. But the thing is when she moved slightly, I don't know what direction it was, but then her painting from behind her came into view, and it was this big face. And so it was just this creepy face that would show up behind her. And it was so distracting, because if she moved a little bit, this face showed up, and it was ridiculous. It was
That's
awesome.
Amazing.
That's great.
Yeah.
Do you have any other tips about just general like court decorum. If someone finds himself in a situation where they're in a court, like obviously dress nice is one rule, but other things that you would say you should always practice, like only speak when spoken to, like, I don't know, anything like that?
So one thing, again, with self-represented people that I find is that they're very hesitant to discuss anything before they get in the courtroom, because I think they think maybe they're being badgered into something. But it's actually very common practice that you go and find the other party before you even enter the courtroom. So I always show up at least 15 minutes ahead. I try and look if the other person's represented or if it's a self-represented person, and I pull them aside into one of the meeting rooms that are usually available in the courts, and just have a discussion, because a lot of the times you'll get in front of the judge and they'll say, did you talk about this before you came in here? Have you discussed settlement? Have you discussed all of this stuff? And if you haven't, sometimes they'll send you out and they'll hear someone else before you, so that you guys can go and have a discussion. So that's one thing that I would say is don't be scared to talk to the other side before you get in the courtroom, because that's actually very encouraged and can be very helpful. And then, so when you get there, there's going to be a docket. This is, again, assuming you're doing it in person. You'll find out where you are. You need to go find the court clerk that's outside, making sure the parties are all present. And then you basically just go in and wait for yourself to be called. And yes, I would say don't speak unless spoken to. The judges are very good at prompting what you should be saying, because they get a lot of self-represented people in small claims. So they're usually very forgiving and very good at making you know when you should be talking and when you shouldn't be talking.
Mm-hmm. That's good to know. What are some other mistakes or things that people who are self-representing tend to do, or some pitfalls of that choice?
So I would say a really big mistake that can be made and is often made is not getting the proper name of the person that you are suing. So instead of putting Dave, putting David, or even if it's a company, oftentimes, like, we go by DC Paralegals, but our legal name is Reilly Cservenyi LLP. If anyone were to sue DC Paralegals, they would get nothing, because nothing that we own is under that name. So that's a really big mistake that you can make up front that will make the rest of the proceedings very, very difficult. The other thing that I would say is an advantage of speaking with a paralegal is knowing the full amount of damages that have actually occurred. And so a lot of times people will come to me and they'll say, I had this driveway redone. They repaved my driveway. I paid them $10,000 and I want to get my $10,000 back because the job wasn't done well. Right? So my question is always, okay, well, to get it redone, it's going to cost you more than $10,000 because now you have to remove the work that they did. Also, were there any kind of periphery damages that might have occurred, such as, did they ruin your landscaping? Did they break your hose nozzle off when they were, bringing in the trucks or anything like that? Because we know the right questions to ask to make sure that we're claiming the maximum amount that we can, obviously within that $35,000 limit. But we know a lot of things to ask that you might not know as a self-represented person, and we can increase that amount of damages, and then you might be able to settle for the amount you wanted to begin with because we upped your claim by $5,000 or something like that.
Right. And does it work the opposite way as well? Let's say you paid someone $25,000 to do your kitchen, but the only part they messed up was $10,000 worth of counters, not the cabinetry, not the island they put in. So you're only really suing for the part that was messed up, not the entire job.
Absolutely. Yeah. So assessing your damages is a huge part of any type of claim, and making sure that you know exactly what it was. Because if you go in front of a judge and you're asking for more than the amount that they cost you, then you're going to be in a lot of trouble. It's the kind of the way that they say it is that you should be put back in the position you were before anything happened. Or I guess the position that you should have been in had they performed the contract. So you're not supposed to be unjustly enriched by the proceedings. You should just be back where you should have been.
Right.
Right.
Yeah.
And we kind of discussed before what happens if you are sued and you lose, and it can impact your credit and there can be liens put on, blah, blah, blah. What happens if you sue someone, but then you lose your case that you're suing? Is there any like impact of the same nature towards you for putting in a claim that is essentially denied? Because I work in insurance and we don't like when people claim. That's not what we want people to do generally, but like that's what we're there for.
Yeah.
But I was gonna say
that's what we're there for. We're there in case you need to. But if someone puts in a claim 3 times in a year, you're like, what are you doing here? And if they're all denied for different reasons, that looks bad upon the person.
Right.
So is it the same way in any other capacity? Does it affect your credit if you sue someone and lose?
So if you lose and it went to trial and you lost, then there can be costs awarded against the plaintiff. And so that would be the cost that the defendant was charged to defend your claim. And so that can happen. If it doesn't go to trial and you just kind of let it fizzle out, then nothing really happens. But it can, I believe, and this is a great question because I don't know this for certain, but I'm wondering if costs could even then, go against their credit, because then it is an amount awarded by the court against you for, the costs of your claim. But I actually don't know that.
We need to get someone on the podcast who works for like the credit bureau and like just talk about credit. That'd be a really good topic. It'd be a little boring, but
I mean, but it's not, and it's something like you said, these are things you should have learned growing up. And I feel like financial responsibility is such a huge thing. And you see it so much in my profession where people just don't understand the repercussions of having a bad credit score. And it's painful.
I see it in my profession a lot too. Like, honestly, like people don't realize that your credit impacts your insurance rates. It impacts like your ability to like get a phone, even. like all these different things. Like so many companies, when they have your name and your address, they have a lot of information, like not specific information, but just some sort of score that tells them about you and how you are with money, and if it's worth them either lending you money or allowing you to have a certain type of like business relationship with them. So
absolutely. And another thing that's actually really important to note in terms of, I was talking earlier about you could get a judgment, and then if you're judgment proof, you might say, oh, they're never going to collect off me. It's very important to know as well that the interest on that amount, there is going to be interest on any judgment that's awarded. And so if you wait 10, 20 years to pay off that judgment, you're going to be owing double what the amount was, or possibly even worse if it's a credit card debt or something like that, where the interest rate is 25, 30%.
Wow, adds up quick.
It's painful when you see that, when it's like they took a $5,000 credit card and now we're suing you for $20,000. It's insane. It doesn't make you feel good.
So we got to do something about some credit or financial responsibility, Dylan.
Yeah, that's
the folks got to know.
And okay, I'm going to be honest here too. Like being in insurance, sometimes I see things in my industry that you like kind of like, just as a general compassionate person, you're like, oh, that sucks for that person who was involved in this. And maybe it was totally their fault. As a paralegal, do you often do you sometimes see things where you're like, oh, I'm going to represent you because you came to me, but I know that this isn't really going to go in your favor. And does it ever take any sort of toll?
Yeah. I mean, so now that I own the company, I get to better choose who I want to represent. And I have turned people away who have seemed like their motivation was a little bit unethical, or their business practices are unethical. And I've just decided not to represent them. But when I worked at the collection agency, I will tell you that hurt. We, like I said, you'll have a credit card debt, and you've got a judgment just sitting there racking up interest. And I had someone who their credit card was like $12,000 and they owed us over $60,000.
Oh.
And they owned $1 million home and they tried to sell it and they couldn't because we had a lien against it. And I felt terrible. But as the collection agency, all they care about is monies. And they're saying, you have $1 million home, so I don't care. I'm going to let this sit here. When you finally sell it, we're going to get our money. So that hurts a little bit for the, human in me. But that's why it's really important that even if you have, I also worked for student debts, like student loans and stuff like that. It's really important to just call the people and work something out with them. And like most places are willing to do payment plans or something like that. But ignoring it is just your worst option. But,
for sure. Yeah. So that leads to just one other question. Then there's no sort of take all comers rule in Ontario court. Cause like I said, I work in insurance, and in certain provinces, there are rules about take all comers. Essentially, like you can't use you may charge a lot more premium for their policy, but you can't decline them. But in Ontario, you can decline taking on a case that you're just like, no, I don't want to represent you.
Yeah. So, I mean, does every person, sorry to cut you off, but does every person have a right to someone to represent them? I would say yes. I would say that generally, yes. But what I would do is maybe refer them out, give them someone else's information, or possibly just say, I don't recommend moving forward with this. And then usually, you don't usually want someone representing you that is not completely confident or, so,
your response probably gives them a lot of information. I don't think you should do this, guy. Okay.
Now, that being said, it's a good point that if I start representing someone and then they start to do unethical things, or even just, some people, you just get that vibe from them, withdrawing mid litigation, like when you're in the middle of a case, is a lot more complicated. You would have to make sure that they have representation. You couldn't just, peace out and leave them high and dry. And if you couldn't find someone, or they couldn't find someone to represent them, you would probably still have to go and represent them. There's very few reasons why you can withdraw representation from a client.
Okay.
Yeah.
Yeah, so we touched on a little bit there, if people have the right to representation. What if somebody can't afford representation? Are there any options in place?
Isn't that part of those Miranda rights in the States there? Isn't that right? Sitting
back to the movie-based knowledge.
Yeah. So we do some pro bono work within our firm when we have someone come in who maybe can't afford to represent themselves. Afford representation. There is legal aid. However, paralegals do not qualify for legal aid. So if you're looking for legal aid, you have to go through a lawyer, and I don't know the exact process for that. I do know that there is a movement towards getting legal aid approved for paralegals, because to me, it doesn't make a lot of sense that we can't.
For sure.
But there are also fee waivers in court for people who are under a certain income level and all that. So they do try and help people, but there is this whole, what it's called is the access to justice movement. And that's the idea that everyone should have access to representation, or at least the information that will help them self-represent. And licensing of paralegals back in 2007 was a huge step towards getting more access to justice for the general public, because obviously we do not charge as much as a lawyer will charge you. And you're getting competent representation that also has a regulatory body. So there are repercussions for us not doing a good job, you know? And so,
Of course.
yeah, so that was a huge step towards helping people who might not be able to afford a lawyer for their small claims court or landlord-tenant board matters.
Yeah.
Honestly, I really did not know anything about paralegals before this.
Yeah.
And I'm so glad that I do now. Like, just like what you've touched on is like, and you kind of mentioned it before that like maybe some judges would look upon like paralegals as like the lower of the lawyer paralegal system, but like obviously they serve a completely different purpose.
Yes.
And that is, I think, something that should be like more spread out there, is that like you don't need to go to a lawyer for everything. Like a paralegal can help you. Like, is there anything else other than small claims court that you can go to a paralegal for advice on?
Absolutely. So, I mean, the ones that we cover in our firm is landlord-tenant board, and then we do some employment law. We also do what's called provincial offenses, which is like traffic tickets or bylaw infractions, those kinds of things. We've got a new paralegal who just started with us this week, actually, who is specializing in criminal law. And so if it's a summary convictions offense. So if you're going to jail for under 18 months, I believe, and then I think the fine, I don't want to be quoted on this because I don't do criminal law, but if the fine is under a certain amount, then you can go to a paralegal for criminal as well. And there's even WSIB, human rights. There's so many different areas.
One question we ask all our guests that we should have asked right out of the gate, but somehow we got into this conversation real quick, is completely unrelated. But what have you been watching lately? What are you streaming? What shows? What movies? What have you been enjoying?
Well, I've decided that I want to watch all of the Avengers movies in order. But then our TV broke. So I think I left off at like, oh man, I think it was like the Iron Man movies, which are very early on. I think I got through like 7 though. I don't know.
That's pretty good.
What I've decided to do, because I'm supposed to technically be on mat leave. I had a baby a few months ago, but I still am working a lot. But when I'm not, I'm watching Avengers.
That's awesome. Nice. Yeah, I was just going to say, it's been a really great conversation. Is there anywhere our listeners can go to learn more about you and your work and what services you guys offer?
Yeah, absolutely. So we have a Facebook page, which is Dean Cservenyi LLP. But instead of going there, just go to our website, which is dcparalegals.ca.
That's great.
Cservenyi, Cservenyi. Nailed it.
Yeah, not hard at all.
Not hard at all.
That.
You got a little spelling sitting behind you there, Reilly. I think Dylan cheated.
Yeah.
I totally did. But we'll put those in the show notes as well.
Absolutely.
Make sure if anyone is listening out there in the Ontario region to reach out to you. Can you represent anyone outside of Ontario?
We can. It's just a lot more difficult, so we prefer to represent within Ontario.
All right. So if you're in BC or something, don't bother.
No, thank you.
Find someone else. All right. Well, thank you so much, Reilly.
Yeah, thank you for having me.
This has been awesome.
Thanks.
Alrighty. Well, thanks again to Reilly for the great conversation today and all the insights on what small claims court is, what a paralegal is. I honestly had no idea what a paralegal was. I've heard it before, but I didn't really know what they did. So that was really interesting for me to learn, and also to learn that being served is not too different from how they show it in Pineapple Express.
Fewer costumes, but same idea.
Yeah.
Next week's guest is going to be Ryan Barnett. He's a good friend, and he knows a whole lot about nutrition. Ryan's worked in fitness and nutrition for the last little while, and he's going to share some of his knowledge with us as he continues to learn more and keep up with all of the latest research and studies so that you don't have to. So anything you've wanted to know about macros, calories, how to lose weight, how to maintain weight, Are you drinking enough water? All of that will be discussed next week with Ryan.
You can find us on Google Podcasts, Spotify, Apple Podcasts, YouTube, and anywhere else that you look for your podcasts.
Be sure to give us a follow, like, and give us a rating if you liked it. Stay tuned for upcoming episodes, and we'll see you again at the Grown-Ups Table.